The evidence question from July of 2001 is about as straightforward a transcript question as the California bar examiners are capable of writing. And there's nothing ambiguous about it. You don't need to read the bottom of the fact pattern first to know that we're in evidence. This is obviously a transcript question. Have a look at the call of the question. At each of the 7 indicated points, what objection or objections, if any, should have been made, and how should the court have ruled on each objection? Discuss. We've got 7 items of evidence. In our minds, we're thinking, we'll throw a quick one-liner in about relevance and then spend all the rest of our time focusing on the objections. As it turns out, this is a fact pattern that relevance really does take a back seat in. We see actually a couple of items of evidence where relevance actually is at issue. But by and large, this is an evidence question that really does focus our attention on objections. And to my way of thinking, this is just about the easiest of the transcript questions that the California bar's ever given. They aren't testing complicated or difficult issues. They are testing quite a few issues with 7 items of evidence, so we've got to go into a reasonable amount of depth under time pressure. Go to the top of the fact pattern, and you see that we're in a typical evidence situation. It's a traffic accident case, and we've got witnesses who are percipient to various events in this car crash scenario. I'm not going to review the fact pattern line by line, as I often do, because I just don't think these transcript questions lend themselves to that kind of work by me in these seminars. So let's look at the outline of issues first instead. You'll see that I've broken everything up in a very standard way. You'll see that relevance doesn't play quite as big a role in this outline as it does in many of my other outlines, even to some of the other transcript questions. And you'll also notice that this time I'm using actual quotes from the testimony as headings. And so I think as you glance through, you'll see that each one of these items gets an adequate amount of attention, although you'll notice item 4 doesn't have any internal headings. And that's because they're really only testing one objection. And it's kind of an unconventional question in that this is the first time the California bar has ever tested it. But by and large, this question is presenting very standard issues in a pretty standard way. Let's just turn to my answer, and I'll show you the details that I think are most relevant for our consideration. This scenario is arising out of a traffic accident, and all of the testimony that we're being questioned about is being offered by the plaintiff. So, in question 1, the attorney asks, after a couple of preliminaries, where were you when you saw the truck hit Walker? There are 2 basic problems with this question. It assumes facts that are not in evidence, and it doesn't really have any foundation. We can't see from the question presented that the witness really has any personal knowledge. So as you look at my analysis, you'll see I do the entire item of evidence in just 4 or 5 sentences. There's not a lot to it. But you'll notice within those 4 or 5 sentences, I focus on both of the objections, and I do so in a way that is quite comprehensive. So we get the maximum out of the minimum in our analysis to item 1. Item 2 also is pretty simple, as all of them are in this question, but we have to go into a little bit greater depth. And this item, item 2, and the next item, item 3, both are a little quirky. This is not terribly difficult, but it also isn't terribly conventional, and that's why I think it's worth having a look at this question. The next question asked by plaintiff's counsel is, what were the weather conditions just before the accident? This is a sloppy question, and it's also a little tricky to analyze. One could argue, as I do, that the question may not even be relevant. Basically, again, plaintiff's counsel has failed to present a proper foundation and to indicate that the witness even has personal knowledge. So, in the end, I sustain both the relevance and the foundation objections. One could readily come to different conclusions here because this is basically just a preliminary question. But in the end, I look at it and I say, this is a red light dispute. This has nothing to do with weather and the question isn't relevant. But again, reasonable people can differ. The witness answers the question in item 3. Well, I'm pretty sure it must have been raining. Again, I have an issue here with regard to relevance. It isn't clear to me how the answer to this question really advances the pursuit of truth or justice at all. The weather isn't relevant to the accident, but again, notice that the witness isn't even sure of his answer. So I indicate that the witness is speculating and that, again, he doesn't have personal knowledge. In the end, I sustain both objections. This issue of lack of personal knowledge has rarely been tested on essays in California or elsewhere. That's one of the reasons why this question is worth looking at. Now look at the question presented in item number 4. Tell me everything that happened. Plaintiff's counsel is doing a distinctly poor job in this case. In item 4, counsel is asked a question that is too open-ended. It's too broad. It doesn't guide the witness through the story. It merely invites the witness to tell an extended story. And that isn't good enough. Counsel has to ask comparatively narrow, comparatively specific questions. The witness has to be guided through the story, not just allowed to talk endlessly. Notice, this is a very narrow question. Item 4 does not ask us anything that really allows us to go into relevance in a standard way, or even in the sort of stripped-down way that we sometimes do on many of these transcript questions. Question 4 is about as narrow a question about an objection as we could possibly see. And you'll see I answer it very specifically, including presenting other questions that counsel could have asked. We turn to item 5, and here we're on much more comfortable ground. This is an item of evidence that has much in common with many other evidence essay questions over the last 30 or 40 years in California. The witness exclaims, "Call an ambulance, the truck just ran a red light and hit somebody." This is a very standard hearsay question, and it is possible that you could even lead off this item with a one-liner on relevance. Obviously, this testimony is supporting the plaintiff's case. You'll notice that I define hearsay within my discussion of the objection, and then I focus on the state of mind and the effect on the listener exceptions to the hearsay rule. These are kind of complicated and not very heavily tested on the essays as well. And that goes on to add to my impression that this is an interesting and a kind of a quirky question. In the end, I focus on excited utterance and present sense impression exceptions, and I admit all of the testimony as an excited utterance. Now, as we work together through a number of evidence essay questions, we'll see that excited utterance and present sense impression are tested together, ritualistically, over and over again, in precisely this way. You'll see this item of evidence again and again. And if you take the bar and evidence shows up on the essay section, there's a fine chance you'll see precisely this issue on your bar exam. Now, turn to item 6. This is another sort of unconventional item of testimony. The witness testifies that he walked over to the window and that he himself exclaimed, "The truck must have been going way over the speed limit." The first objection to this testimony is one that we will see a number of times in our work together in this seminar. Part of this answer is non-responsive to the question. The questioner asks, "What happened next?" The witness answers, "I walked over to the window and looked out." That part of the answer is legitimate. But then the witness goes on to testify as to a comment that he recalls making at the scene at that point in the chronology. And that part of the testimony gives rise to a hearsay objection. The witness is right here in court, but the statement was made outside of court, and it can't be presented as evidence unless there's some exception or exclusion. And to be honest with you, I can't come up with any exception or exclusion. I don't think any exception covers this part of the testimony, and so I don't think it will be admissible on hearsay grounds. Finally, I reach a little more deeply to come up with one more objection, which is that the witness's comment about presumed truck speed is impermissible opinion. It's common for witnesses to offer similar opinions, but this witness didn't even see the collision. All he did was hear it. So I sustain the objection on improper opinion grounds as well. And that brings us to the very last item of evidence, and this is a fairly complicated situation as well. Here, the witness is testifying as to some interactions between Dan, the defendant driver, and another witness, a woman who kneels down next to the victim along with Dan, and this woman speaks calmly to Dan and says, "It's all your fault." And Dan says nothing in reply. And you'll notice that this is perhaps the most elaborate section of my answer. I talk about hearsay. And it seems to me that in order for this interaction to be testified about in court, both the woman's statement and Dan's lack of response will have to fit into some exception to hearsay, or else they won't come in. And I don't think either link in this chain is going to end up being admissible. The woman's statement was made calmly. It wasn't made in a way that was a serious challenge. It wasn't an excited utterance. And it also was made later after the accident. So it isn't a present sense impression. I don't see any exceptions or exclusions, and so I don't allow this testimony in from the very beginning. And without that out-of-court accusation by this female hearsay declarant, there's no foundation for the silence of Dan in response. And here I get into a little bit of a discussion about adoptive or vicarious admissions. It's kind of an interesting issue, but in the end I sustain the hearsay objections, and I do not admit this evidence. And that wraps up a consideration of a very simple and straightforward transcript question that presents narrow issues in kind of an interesting and somewhat unconventional way.